Florida is one of the only 6 states that use 6-person juries for any criminal cases where a death sentence doesn't apply. On Monday, the United States Supreme Court agreed to hear a case that could require 12-person juries for all felony trials. As News 13's Grace Velez tells us, both sides of this argument make good cases regarding their interpretation of the Constitution's 6th Amendment.
The case of Kian versus Florida has sparked a constitutional challenge. Hamed Kian's lawyers are working to overturn a 1970 decision that allowed state courts to use 6-person juries.
We, Florida prosecutors, have been following the law as we were told by the U.S. Supreme Court. So if they decide to change it now, it could have a profound impact on our criminal justice system.
Some criminal defense attorneys are following the case with a different mindset.
It's a lot more difficult to convince 12 people than 6, and the only way the state wins is to convince everyone on that jury. If it's a unanimous not guilty verdict, the defense wins. If it's a hung jury because the jury is not unanimous, my client still walks away without a conviction.
Al Salim previously practiced law in 2 other states. He says 6-person juries took some getting used to.
When I moved here 22 years ago, it was culture shock. I am licensed in Ohio, Washington, D.C., and the United States District Court. And the idea of only a 6-person jury was just mind-boggling. It's not even something that is discussed in most other states.
Using his own words, there is something Salim finds more mind-boggling when it comes to how capital sexual battery cases are tried.
If you get 6 people to convict, the judge has no discretion. It is a mandatory life sentence, which means an individual can be sentenced to life in prison with only 6 people casting judgment and not 12. That's scary when you think that a person could go kill somebody, like a DUI manslaughter, and receive less.
While Salim says a 12-person jury could change the outcome in many cases, Basford argues the data doesn't back up that claim.
There's no research that shows that conviction rates go up or down with a 12-person jury versus a 6-person jury.
If the Supreme Court overturned 6-person juries, Basford said it could have major implications on thousands of cases under appeal.
Right now, there are 5,000 cases that are already under appeal, or pending, I should say. And all of those individuals, if they were convicted with a 6-person jury, would also say that, wait a minute, I should get a new trial because I was only tried by 6.
Basford also pointed out if you use common law language to decide the makeup of a jury, that jury would end up being all men. Switching to a 12-member jury may slow down a judicial system many feel already moves too slow. But Salim says when you're talking about a life sentence, a few extra workdays doesn't seem significant.
There is another way of doing things. Whether it's better or not can be debated, but this idea of, well, this is the only way it can be done and everybody else is wrong, I just don't buy that 45 states are wrong and only 5 are right.
In Florida, Grace Velez, News 13, Panhandle Strong.
Justices are set to hear Kian versus Florida this fall and will decide if a 6-person jury violated Kian's constitutional rights.